Broder testify about Native Hawaiian people and how they still have their culture and how important the land is to them. She's the first person to get a PhD, first Native Hawaiian to get a PhD at the University of Hawaii and to be able to read the original source materials in Native Hawaiian. Pualani Kanakaole Kanahele also testified. She's a great hula instructor. She's very knowledgeable on the philosophy and traditions and culture of the Native Hawaiian people. She's nationally recognized as a national treasure. David Getchys, who wrote the book on federal Indian law, he testified. James Anaya, who is very active internationally, he testified about international law and how it was applicable to our situation. He's now a special rapporteur for the United Nations Commission on Human Rights. Okay, here's the other team, is me, Ken and Shanmugam. This case ended up at the U.S. Supreme Court, so when we got to Washington, D.C., we had to hire Supreme Court practitioners, and we originally hired Neil Katyal, but he ended up going to the Solicitor General's office, and he's now actually the acting Solicitor General. So we had an opportunity to work with him. He's really fabulous. So Cannon actually argued the case when we went to the U.S. Supreme Court, because the traditional advice is you need somebody who argues all the time. And he did a wonderful job. I was very impressed. Melody McKenzie, she's wrote the Native Hawaiian Handbook, and you recognize Professor Van Dyke, I'm sure. Okay, so the Hawaii Supreme Court agreed with us. They issued an moratorium. They issued an injunction. They found that reconciliation was ongoing, and they restricted the sale of the ceded lands. So we were pretty happy. We thought that was pretty good. The opinion was fantastic. It was unanimous. The Chief Justice wrote it. They recognized that Hawaiians had unrelinquished claims to the land, that they were taken without compensation, without consent, that they were taken illegally. They recognized the cultural importance of the land. And they said that once ceded lands are alienated from the public trust, they will be gone forever. So, the court really got it. They understood the importance and the uniqueness and the special nature of the lands to Hawaiian people and the importance of having a moratorium. Unfortunately, the governor and the attorney general of the state of Hawaii decided to petition for certiorari, because there's this opinion of the state Supreme Court, so you can petition for certiorari directly to the U.S. Supreme Court. They petitioned, and the court granted certiorari, unfortunately, so we lost our beautiful, wonderful, fantastic opinion of the Hawaii Supreme Court, saying that this was going to be a moratorium until the claims of the Native Hawaiian people have been resolved. When I would go to court, the trial court would say to me, well, Ms. Broder, when you say that, until the claims of the Native Hawaiian peoples have been resolved, when is that going to be? I mean, how long are you talking about? Are you talking about 10 years? Are you talking about 25 years? Or are you talking about another 100 years? And I would always say, well, I guess that'll give an impetus to move the process along more quickly. Okay, so Justice Alito wrote the opinion. One cert was granted. From a lawyer's point of view, it was interesting to work with the Supreme Court practitioners, because they were very definite. They said, cert's been granted. They didn't grant cert to affirm. So now your job assignment, I'm a lawyer, I'm a litigator, so my usual view of my job assignment is to win the case. But the Canon, Shanmugam, and Neil Katyal will say, what you got to do now is limit your loss. You've got to figure out how to lose this case and not lose too much, because, we didn't want them to say the Hawaiians have no unrelinquished claims to the land. We didn't want them to, come up with a big, long opinion and say something terrible that would haunt us forever, and we wouldn't be able to proceed. So So we narrowed the case down. We said, just reverse and send us back to Hawaii. Just vacate the opinion, send us back to Hawaii for a new opinion. I'm sure the court can get it right the next time around. And so we did. We escaped the bullet, and the court did vacate the opinion, but they didn't really make any ruling. So it's only a 9-page opinion. 7 pages of the 9 pages are all prefatory discussion, and then the last 2 pages are a little bit of a discussion. But they did leave a little bit of a roadmap, in my opinion. They cited other federal statutes approvingly where there was recompense to the people to whom wrong was done. For instance, the Japanese Americans who were given $20,000 each for internment during World War II. The downwinders and the radiation exposure cases in Nevada and Utah, and they got $100,000 each. So they recognize that the government does do that. The federal government does do that, does pass statutes to make amends for wrongs in the past. And then, thank goodness, they decided that they had no authority to decide the questions of Hawaiian law or to provide redress themselves. So they stayed out of it. They just vacated and sent back. So we thought it provided a roadmap that the Hawaii Supreme Court could, issue its own opinion still, that through the legislature, the people of Hawaii could come to a resolution of this, and that the claims to the federal lands could be resolved by the U.S. Congress. However, as soon as cert was granted, I figured, well, there's more than one way to win a case. There's another branch of government. So we immediately ran over to the Hawaii State Legislature to get a law passed in case the opinion was vacated and we didn't have the moratorium, to get a moratorium in the legislature. And so we did a deal with the governor, and we agreed that we would dismiss the case without prejudice if the governor supported and the law passed to make a 2/3 vote of both houses of the legislature to sell any of the ceded lands. And the governor was required by the law to take any proposal to do that to the community where it would be affected first before coming to the legislature. And of course in Hawaii, everybody loves the land so much. It's pretty hard if you have to go to the community and ask them what they think. Usually people are against it. So one good result of the case, though, was that they had started to develop these lands on Maui, the little sugar lands, and they had put in sidewalks by the time we filed our case. And they had, made some roads and stuff. And so they had a capital investment in that. And so we agreed with them that those lands could actually be used for the Department of Hawaiian Homelands, which is for Hawaiian people. So actually today there are Hawaiian people living in these. This is now Hawaiian homelands, and Hawaiian people are living in these homes. Okay, so now what is pending in Congress is a bill to reorganize the Hawaiian self-governing entity, and this is called the Akaka bill, and it's been pending in Congress for a few years now. It would establish a process to organize the Native Hawaiian governing entity. You may remember that Professor Van Dyke said that the Native Hawaiians are the largest group of Native peoples in the United States and have no self-governing entity. So this is to fix that. And Native Hawaiians are specifically excluded from the BIA process, which allows Native peoples to petition the Bureau of Indian Affairs to become recognized. Native Hawaiians are specifically excluded from that law. It's for the 49 states, not the 50th state. Okay, and it would guarantee federal recognition. It would call for some negotiations of the assets after there's a recognized Native Hawaiian entity. Again, it would have findings of the special responsibility of Congress in the United States for Native Hawaiians, recognizing their distinct indigenous status, and also, again, recognizing that the state of Hawaii has a broad responsibility to administer its lands in trust for Hawaiian people. So there would be negotiations, there would be a development of a role as to who would be Native Hawaiians. Who is a Native Hawaiian and what percentage of blood you have to have is a controversial issue for Hawaiians as it is for other Native people. So this would set a standard for it, but it would be open to negotiations with Hawaiian people after the entity is recognized. So here's the definition of who is a Native Hawaiian in the bill at the present time. And as I was explaining, Native Hawaiians can change the criteria later on. So what should be the basis of the lands for the Native Hawaiians? Well, it could be the crown lands, as Professor Van Dyke was telling you about and explaining the history to you about where those lands came from and why that would be a good argument to make and why there's moral and ethical justification for that. There's also the Hawaiian homelands, which is about 203,000 acres, which is already existing from the 1920 statute. There's Kaho'olawe. When Kaho'olawe was one of the islands of Hawaii, it was used for a bombing target by the U.S. Navy and was finally turned over to the state of Hawaii about 20 years ago. And when it was transferred from the military, from the U.S. Navy to the state of Hawaii, the federal law said that it would be held in trust by the state until a Native Hawaiian nation was formed, and then the intent was that Kaho'olawe would be transferred to a Native Hawaiian nation. Of course, Kaho'olawe still has unexploded ordinances on it and other things because it's not that easy to clean up after the U.S. military. So and then there's the elite states like Kamehameha schools, some of the nobility of the royalty of Hawaii when they passed away and they had no children, they set up trusts and they left the lands in trust for Native Hawaiian people. Here's the cover of Professor Van Dyke's book, some of the lands, and the government lands, the crown lands, and how it's divided up. And did you bring a copy of the book? No, here's a copy of the book if anybody wants to just peruse through it. Okay, another case that I worked on was for Hawaiian language, because Hawaiian language was outlawed in Hawaii, so today hardly anybody speaks Hawaiian. The Constitutional Convention in '78 urged that the Hawaiian language and culture and tradition be promoted in the public schools. And so, of course, not too much was done, so we sued the state over providing inadequate funding for Hawaiian language and Hawaiian immersion language. And after several years of litigation, the state did agree to settle that case, and OHA agreed to match the funding. So the state would spend $2 and OHA would spend $1. And so the program has grown bigger since then. So today there are 3,000 speakers of the Native Hawaiian language. But that's kind of what all of this is about, you know. It's about reconstituting the Hawaiian people and allowing them to more pursue their culture, language, and tradition, lifestyle, philosophy. So, well, one thing people say, well, what can we do? Well, we could possibly file a petition to the Inter-American Commission on Human Rights, file a complaint with the Human Rights Committee of the United Nations. So there are things that could possibly be done at the international level. So here is our state motto, which is in Hawaiian, and it's translated. It says the righteousness of the state is vested in its lands. So, and as you can see, Hawaii is a very beautiful place. Mahalo.